Hi, welcome to Chapter 7 discussion on judges. Let's talk a little bit about the roles and duties of judges. For the most part with judges, you're going to have judges' duties divided between pre-arrest all the way up through post-trial adjudication duties. Okay, now judges may appear powerful, but really they have a limited authority. Judges have to wait for cases to come to them. They don't get to go out on the street and decide, hey, I just saw a crime, I want that case in my court. And so really they're waiting, kind of waiting around to see which cases are assigned to them. And then they have limited authority both at the pre-arrest, the pre-trial, the during the trial, and then any post-adjudication. Now, sometimes their role is a little bit more active than others. For instance, in trial, they have very active roles because they are acting as the referee of the court. Let's talk a little bit more about roles and duties. Let's talk about post-arrest and pre-trial roles. Now, the first time a judge really sees a defendant is at the initial appearance. And that is where a person who's been arrested is brought to them. The judge informs them what they're being accused of, and the judge typically will assign bail at that point. Next time a judge may see them is at arraignment. That is the first official pretrial proceeding in which the person is formally informed of the charges against them, and they are allowed to enter a formal plea. Most defendants at this stage enter a plea of not guilty, and that just begins the pretrial process. Judges also have different roles during evidentiary hearings where they are determining what evidence is going to be allowed into trial. Those are motions hearings. And then also at plea deals. Judges do encourage plea deals sometimes because really that's the only way that we would have judicial economy. There is no way that every single case that gets or every single case that makes a docket, there's no way each case could be tried. There's just not enough hours in the day, days in the week, and so on and so forth. And really only about 1 to 5% of the cases ever actually see trial. And so plea deals are just a way to move the docket along. Okay. And usually the prosecution and the defense, they tend to know their judge and know what kind of deal a judge would accept. A judge does not have to accept a plea deal. The judge could refuse to take the plea if the judge feels like the agreed upon deal is not in the best interest of justice, whether or not the judge feels like the punishment would be too light, too harsh, whatever it is, the judge has to agree to it. Roles and duties at trial. The judge is highly visible at trial because they're going to rule on any objection and they're going to rule on all the rules of evidence and determine what comes before the jury. The judge is also highly visible during instruction. The judge is a big part of voir dire, and explaining the rules to the jury. The judge is also going to explain the rights during jury instruction, the defendant's rights versus the state's rights. Okay, and really the whole purpose of a judge is to maintain the dignity of the court and to ensure fairness. Really that both sides play by the rules. And those rules are the Code of Criminal Procedure and the rules of evidence, as well as various professional responsibility rules that you all looked at last week or the week before. What is the judge's role post-trial? Well, post-trial, a judge is supposed to impose a sentence, and that sentence can be made up of many, many different things, whether it's probation or jail or a combination thereof. Some courts, like federal courts, have sentencing structures, and that's going to determine the judge's limits. Also, some crimes in and of themselves are the charging instrument. If the person is maybe on a 3 strikes, they're going to be looking at mandatory minimums. So the judge is probably going to have parameters set up not only by how many times the defendant has convictions, but also based on the offense itself. Misdemeanors in Texas If it's a Class A, you're looking at up to a year in the county jail. If it's a B, up to 6 months. If it's a felony, depending on the level of felony, you're looking anywhere from, 2 to 99 years. Judges also look at probationary sentences, and they're going to look at, well, if the person's on probation, what do they have to do? Do they have to attend classes, community service hours, pay fines? What exactly is it that they're going to be doing on probation? And the judge is also going to consider, well, if the person messes up their probation, they're going to have an underlying sentence. So let's say it's a Class A assault, and you're looking at 18 months probation, but the underlying sentence, because it's a Class A misdemeanor, is 365 days in the county jail. So if the person messes up on probation, the judge may impose that year in jail. For probation violations, the judge is going to look at, was probation violated? There will be a document called Terms and Conditions of Probation, and these are the rules that the person has to follow if they want to stay on probation, because probation really is a privilege. If a person messes up on probation, meaning they are not capable of reforming their behavior in public, then they're going to be removed from the public and they're going to be placed in jail. Okay, and then the judge is going to have to determine the appropriate sanction. Administrative duties. Judges are really the managers of their courtroom. They are going to be, kind of like the principal of a school. They're going to set all the rules. They're going to monitor the courtroom and support staff, and they're going to be the boss. They're also going to set the timetable. When is court going to start? When is it going to end? When are cases going to get set for trial? What is the order of pretrial? Some judges have 2 pretrial hearings, then a judges conference, and then it gets set for trial. Other judges do it on a case-by-case basis. Some have a different format. So, the judge is really going to be in control of those administrative duties. Let's talk a little bit about judicial selection. On the federal side, there were some colonial misgivings. Our founding fathers didn't really trust the courts too much. And so that was pretty evident in the way the government was set up at first, because the courts didn't have a lot of power at the beginning. It wasn't until Marbury versus Madison when you started to see equal footing between the executive, the legislature, and the judiciary. So how do federal judges get on the bench? Well, they are appointed by the president, and then they are eventually ratified by the Senate. Now, the Senate Judiciary Committee, which is a subcommittee of the Senate, hears nominees, and then they also nominate in some cases. A federal judge is a lifetime appointment. The person is there until they retire, or unfortunately, some of them die while in office. Very, very few judges are ever removed. There is a removal process. It's impeachment, and they have to be impeached in order to be removed. They can't just be fired. That's one of the powers of a federal judge, is they are there for lifetime. State appointments. Now, different states have different rules regarding their judges. Some states require appointment, meaning that there's some kind of either partisan or nonpartisan or merit selection appointment. And it's very state specific. Every state has their own rules on how state judges get their posts. State appointments often are met with inherent distrust, because it really depends on who's appointing and how did they get appointed. Was it something that they earned? Were they somebody's buddy? And really, state appointments are pretty unpopular these days, because the majority of the population want to have a say in who. Most of the time, they're really not challenged, and you see that a lot. In fact, in El Paso, most of the time, you'll rarely see a judge that's been there for a while being challenged by anyone. Usually, it's an open bench when a judge retires, and then you have a lot of different people trying to run for office. Next, there are state merit selections. Now, merit selection is kind of a compromise between the appointed system and the elected system. You have some kind of bipartisan committee that has a set of policies and guidelines on who can be nominated, and then you'll get a nomination. The governor then selects the nominee, and then there have retention elections where the public can determine whether or not they like the judge. So it is an appointed position at the beginning, but then the judge goes up for re-election. So maybe this is a family court and the judge is very partial to either women or men in divorce, whatever it is, and the public can have a say. Maybe we don't want this person to continue being a judge. And here is a chart that shows judicial selection by state. Oh, and Texas should be on here. I just realized it's not. Texas would be under partisan election. Ah, there we go. It was on the second page. My apologies. All right, diversity on the bench. Is there diversity? Well, not so much. The vast majority of judges are white men. Okay, and there really does lack a diversity on the bench. For instance, federal judges in the Southwest, there's very, very few female federal judges. Judge Cardone here in El Paso is the first female federal judge in the Western District of Texas, and she's one of the few in this area of the country. But as the number of women and minorities in law schools continue to rise, we're going to see more diverse appointments as we start having more and more women and minorities in law school and graduating. And ladies, I can say that I believe at this point, women are at least 50 to 53% of most law school classes. Here's some stats. Appellate court judges, majority male, and you can see the way that it breaks down in terms of ethnicity. Let's talk about socialization and development. There's really a lack of judicial training. Usually if a person runs for judge, they get elected, and most of them are former lawyers, and they really just learn on the job. They'll get CLE classes, which is continuing legal education, that teaches them how to be a judge. But most of it really is on-the-job training. Your book talks about the black robe disease, which is kind of this inflated sense of self, this kind of inflated sense of importance. And what I can tell you is the best judges really are those that know that they don't know everything and that are constantly trying to improve and constantly focusing on being fair and following the laws. Other socialization and development for judges is the National Judicial Conference. Now, each state has their own education conferences for judges, but this is a national conference that happens. It's training for judges. Not every jurisdiction gets to go because it is expensive. And one of the things about it is that it allows judges to get together and talk with one another, because judges really are in their own little worlds. They have their own courtroom with their own staff, and they don't really get to work with other judges very often because they're each in charge of their own docket. So going to conferences and networking and talking to other judges really helps them, find that sense of community and really talk through issues that they may be having in their courtrooms. Let's talk about judicial accountability and independence. Accountability. There has to be some kind of accountability for judges. We can't have a judge that just does whatever he or she wants without any regard for the law. So there are ways to remove or discipline a judge. In a state where there's elections, Those judges are up for election every 2 to 4 years. There's also a balance. There's judicial, how do we have judicial autonomy where we have judges being able to make the tough decision, but then how do we also have oversight? So there's this kind of delicate balance between allowing judge to be independent and to make the right decision. And sometimes the right decision isn't popular, but it's nonetheless the right decision. So how do you balance that with allowing them the freedom to make those decisions versus ensuring that they are following the laws and doing what they are supposed to be and following all ethical rules? Judges do have decisional accountability. They have to answer for rulings. Sometimes it's just in the court of public opinion where news articles will be written about them. Other times it's people will complain to the state bar and file an ethics violation on a judge, and then you will have the state bar investigating the judge. And they also have behavioral accountability, their conduct on the bench. A judge has to behave appropriately. Judges can't engage in just any behavior they want. And what you'll find is most judges do not have social media accounts. In fact, federal judges are told they are not allowed to do so. Okay, and judges really do have to maintain that public trust. So how do they do it? Well, they do it by leading by example, at least you would hope. Now, there's always news articles about judges who behave badly, but we hope those are few and far between. Independence. Judicial independence is very important because we need judges to feel free to decide cases. Why? Because we want them to do so fairly and impartially. We don't want judges to feel social pressure because we want them to make decisions based on the law and based on justice and fairness and not on, whatever the masses want. Now, sometimes, courts have to change with society. Just like we saw with Brown versus Board of Education. Okay, but we also want to be careful that they are able to decide without, undue influence, undue pressure. You don't want judges having financial pressure or political pressure. That's a reason why the federal judges have lifetime appointments and they don't have to worry about being elected again. That way they can hopefully make the right call and not just the call that their constituents want. What about accountability and independence when those two come together? Well, there are performance evaluations. As some judges that are appointed, they have to maintain certain scores. They are expected to be quality judges. They have to be experienced evaluators, that evaluate these judges. And also there's the recall vote or the retention vote, and that's when you'll see increased voter participation. There's also accountability for judicial misconduct. There are judicial disciplinary commissions, and there's usually one per state. If a complaint is made, an investigator will be assigned. They will investigate the misconduct, and if they find that it's valid, they can impose discipline all the way up to revoking the judge's right to practice law. Ladies and gentlemen, that's all I have for you for this discussion. Hope you have a great rest of your day.